Just like in a regular court, the defendant, which we call the accused, in the military is presumed innocent until proven guilty by legal and competent evidence beyond a reasonable doubt. So the standard's the same, and just like in the civilian system, there are sort of gates along the way that he has to pass through before he would even get a trial. And here the gate, much like in the civilian system where there's a preliminary hearing or a grand jury, we have what's called an Article 32 hearing. But right now, I mean, we're at the very beginning. And so what will happen now is the defense attorney, and he has very able defense counsel here, will not only do his own personal investigation, look into the individual's background, his military records, his meetings, his personal private meetings with the accused, and then any discovery that the government would give him, and decide whether or not there are any particular defenses that may work better than not. The defense that was floated out there earlier was the possible defense of mental incompetency. PTSD, post-traumatic stress disorder, is not per se a defense. It would be part and parcel of a mental competency defense, and the rules for court-martial under Rule for Court-Martial 909 and 917 lay out the rules, and basically the court would have to find that the accused cannot meaningfully participate in his defense and is not competent to participate in his defense for him not to be mentally competent to stand trial. This defense attorney is just outstanding. I mean, he's a seasoned, battle-hardened civilian defense counsel. He has the right qualifications for this case, especially if it's referred to be a capital case. And the short answer is no. When you have a defense counsel of this caliber, I mean, if I was charged with a crime, I'd want this caliber of defense attorney defending me.